Variance Board meeting for July the 10th, 2013 at 10 o'clock a.m. Board members present to my left is Jason Lanyon, the Fire Chief, and to his left is Scott Stokes, the Director of Public Works. And we have Rosemary Rivera. She's the Executive Assistant to the City Administrator. She will be taking the official meeting minutes. First item for business is a public hearing, V13032, Appeal of Community Development Director's Interpretation of Zoning Conditions and Requirements regarding a buffer, Land Lot 241, Concord Walk Subdivision, Timothy and Terry Evans. And I think the attorney, you're going to start first?
Yes, ma'am.
Okay. And for the record, can you state your name?
My name is Matt Clace from Webb, Clace & Lemond here on behalf of the Evans. Essentially, you summarized it well. This is an appeal of a decision of the Community Development Director. We have, I'd like to give an opening presentation. I'd like to get some testimony from my clients briefly, and also there's some exhibits that I'd like to introduce. And I actually have a set of copies for each one of you so you can follow along, if I can bring those forward. Essentially, just to start off, these folks have been residents for over 10 years at 118 Jeffrey Place. That's in the Hampshire Place subdivision. They're quiet, tax-paying folks who have never had an issue with their property until recently. They never previously filed any complaints of any kind with the city. They hate to have to be here today, but they really believe that the Community Development Department has misinterpreted a city zoning law to their detriment. Now, they're not saying this interpretation was intentional or taken with some malice. They just think it's a mistake. And we're here today respectfully to ask that you correct that mistake. The evidence will show that in the 2002 to 2003 time frame, the Evans were looking for a new home. They had recently been through a family tragedy and were looking for a fresh start, a tranquil, naturally beautiful property that they could enjoy for many years. They identified the property at 118 Jeffrey Place, which was still under construction at the time. It was a unique property. You'll hear some testimony on that. It's set far back off of the road and surrounded on the back by green space. It's lush green space, naturally beautiful environment. Now, as a condition of purchase, they wanted to make sure the green space would remain. As luck would have it, the neighboring subdivision had been permitted on the condition that a 20-foot natural and undisturbed buffer would separate the properties. The developer, who was Ed Hatcher, showed them the city council minutes where this condition was imposed and showed them the plat, which clearly set forth this requirement, undisputably, signed by several city officials as being approved. They were satisfied with this, that the natural beauty of their views would be preserved, and they bought the home. Now, for over 9 years, they enjoyed their property without interruption. The buffer area separating the property was preserved. It was not disturbed at all. It was lush and beautiful, and you'll see photographic evidence of that. Now, in 2012, that began to change. The owner of the neighboring property, Mr. Gemarillo, began to remove and thin the naturally occurring foliage in the buffer. Now, Ms. Evans complained to code enforcement, citing the 20-foot natural and undisturbed buffer, which was a condition of that property. And code enforcement acknowledged the existence and validity of the buffer, but they claimed that the neighbor's actions were nonetheless allowed by the zoning code, Section 503, which we'll look at today very closely. Now, in addition to disturbing the green space in the buffer, the neighbor erected an 8-foot tall fence around the buffer entirely, thereby depriving my clients of the views which they had enjoyed and which would have remained under the zoning condition. So instead of looking out into a lush, beautiful green space, they were now looking at an unsightly, a tall fence that completely blocked their view. Now, I think as is obvious, a man-made fence is neither natural, and erecting a man-made fence inside a natural and undisturbed buffer is a disturbance. The neighbor has taken trees out of the buffer, he's taken underbrush out of the buffer, he's built the fence in the buffer, and this has gone on over the last year and a half periodically. It wasn't just a one-time thing. It's continued to get thinner and thinner as the last year and a half have gone on. And I think, as we'll show today, that the city's interpretation of its law, specifically Section 503, to allow these activities is a mistake. It's just mistaken, and it should be corrected. Section 503, by its own clear terms, is only applicable when residential and non-residential properties abut. Here we are dealing with two residential properties. Nothing in Section 503 about rules relating to two residential properties, as is the case here. I think you'll agree that Section 503 is inapplicable after seeing the evidence and looking at the code section, and that the activities that took place in the buffer were violations. And we'll ask that you reverse the city's interpretation. Now, to begin, I'd like to get you to hear some testimony from my client, Terry Evans, if that pleases the board.
Good morning. My name is Terry Evans.
Excuse me. Jeffrey, does anybody need to be sworn?
Yes, I was going to swear her in.
Okay.
Yeah,
all
I
right.
was going to say, let her attorney swear.
Okay.
Ma'am, could you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Deal. You'd stated your full name. Could you spell your first name for the board members?
Terry, Terri.
And what is your current address, Ms. Evans?
118 Jeffrey Place, Smyrna, Georgia, 30082.
I want to show you what we've marked as Evans Exhibit 1. You all have copies up there. And if you could describe for the board what this exhibit represents.
This represents the plat of the subdivision in my property as well as the adjoining property, Concord Walk. And it shows my lot right back here. Number 9. Lot 9 is ours. We're at the very back of the community here.
Now, how long have you lived at this property?
We moved in February of 2003 when the home was ready.
Now, take me back to the time frame when you bought the home in 2002, 2003. What was going on with your life back then?
My husband and I have been together about 25 years, and we were living in a large house in Lawrenceville, and we lost our daughter very young. This was right about the time of September 11th, so needless to say, we were very devastated. So we immediately put the home on the market because emotionally neither one of us was in any condition to stay in the home after the loss of our daughter. So we began looking for a new home, and specifically something far away from Lawrenceville. We had been very actively involved there in the homeowners association, all the activities. It was a large community, 300 to 400 homes, a lot of kids, a lot of activity. So after we lost our daughter and sold the home, we were looking specifically for something that would offer, particularly me, something peaceful, a respite. So when we saw this home, we originally came to the city of Smyrna after looking at many, many, many houses. Our realtor took us to probably 30 or 40 homes. And when we came to Smyrna, we came specifically to see the Benchmark subdivision that was going up on Concord Road. And we happened to run into the Hampshire Place subdivision, where we found Mr. Hatcher at Hatcher Homes building this last home. And the location of the home was perfect for us. It is set so far back off the road. It's very private. It's very quiet. And then on the left side of the home, we saw this beautiful green space. And it was so peaceful and so secluded that we felt like we wanted to buy the home. But my husband and I both had concerns what would happen to this beautiful piece of lush green space. So we asked Mr. Hatcher, what is this property? He said, there's an easement on there, and it's a natural undisturbed buffer. I said, well, can anyone erect anything or anything be built in that area? And he said, well, Miss Evans, there's not a big space. Nothing can go there. I said, what about a fence? Could a fence go there? And Mr. Hatcher said, nothing can be erected in that space. It cannot be disturbed. It's a natural undisturbed buffer. So not knowing Mr. Hatcher or the city of Smyrna, we asked him to please produce the documentation at the zoning, and then we understood that in 1994 the zoning was changed to RAD conditional. We looked at the minutes, we read the minutes, we looked at the code, we talked with Mr. Hatcher, and at that point in time we felt satisfied that the space would remain natural and undisturbed. So we did purchase the home.
I want to show you what we've marked as Evans Exhibit 2. If you could take a look at that and let me know if you've seen that before.
Yes, these were the minutes that we read.
from the meeting where the Concord Walk property was rezoned?
Yes, sir.
Okay, if you'll turn with me to page 3, there's a star and an arrow pointing to a paragraph. Did you specifically look at that paragraph?
Absolutely. It was very important. The language here was very important to us.
What was important about it?
Well, in the language, it says that Mr. Thompson stated that he would work with the property owners and provide some type of buffer between the properties and will attempt to have as much vegetation as possible to provide a visual buffer between the properties.
And if you turn over to page 4, where it lists the conditions on the approval of the rezoning, is there a condition that's relative here?
Yes, sir. The buffers will be provided as agreed to by Mr. Bradley Thompson, i.e., a 20-foot undisturbed buffer from the right-of-way of Concord Road for those houses which abut Concord Road, and install some type of buffer between the rear yards of the newly constructed home where they abut other residential properties.
And I'm going to show you Exhibit 3. Let me know if you've seen that document before.
Yes, sir, I've seen this document.
And was this shown to you before you purchased your home?
Indeed, this is the plat for the Concord Walk subdivision.
And does it note a buffer on there?
Oh, yes, sir, clearly. Natural and undisturbed buffer, and it was pointed out to us by Mr. Hatcher as well.
And what does the second page of this exhibit represent? Is this appear to be a blow-up of the...
This is an enlargement of a portion of that subdivision, marking clearly the natural and undisturbed buffer.
Going back to the first page, this plat is approved and signed by some city officials over there on the right side. Looks like several city officials signed that. Did you notice that when you first saw it?
Absolutely. I wanted to authenticate the document.
Okay. And that was important to you that those city officials had signed that?
Well, I wasn't going to buy a $300,000 home if I had not verified what the builder was telling me.
Now, the phrase natural and undisturbed, what does that mean to you?
Natural means undisturbed. It's natural. The natural growth that occurs, the underbrush, the trees, the shrubs, natural, meaning it is as God created it, and it shouldn't be disturbed.
Now, take me through, after you purchased the property, what the property was like for the first 9 years you lived there.
Paradise. Paradise. It's a beautiful home. We invested a lot of money in the home. Our neighbors are wonderful. I spent many hours in the backyard reading, trying to, get beyond the tragedy that we had suffered. So my backyard particularly had become a respite for us, for both of us. It was very peaceful. You could hear nothing back there but the trees. It was full of greenery and trees and the birds and the squirrels, and it was absolutely beautiful for 9 years. We have loved the home. We love the city of Smyrna.
I want to show you Exhibit 4, which are some photographs. If you could hold these up and show to the board what they represent. This is Exhibit 4.
This is our home, and this was taken in the fall of the year. And this is before any of the natural buffer was undisturbed. And you can see that there are multiple large trees, shrubs, underbrush throughout that piece of property there in the natural and undisturbed buffer.
And what's the second photograph in that exhibit?
This would be in the spring. This is the spring of the year, and as you'll see, to the left side of the home, you can see nothing back there. All you can see is trees, plants, and shrubs. You can't even see another home there. You can see nothing there but the green space.
And where is your neighbor's home in relation to your house in that photo?
My neighbor's home would be right here on this side of the green space, to the left and back of the green space.
When did you first start to notice that there was an issue with the buffer?
Early in 2012, I travel for business so often. I'm gone all week and I'm home on the weekends. And my husband and I would discuss that we felt the green space had gotten thinner. Well, we knew no trees had fallen. We had lived there 9 years. We'd never had a tree fall back there, nothing. And we noticed little by little that it began to thin out around sometime the early part of 2012.
Did it get worse?
Oh, it got much, much, much worse. Around April of 2012, I was in the backyard and I saw two gentlemen in the green space with chainsaw. And I heard the chainsaw and the starting of the cutting of the trees. Never seen this neighbor before, never met this neighbor before. With the green space in between us, you just don't see people from the other subdivision. So I went out to my backyard and I motioned to please stop and indicated to the neighbor that this was a natural undisturbed buffer. And in my mind, the neighbor was unaware that he had property with a natural undisturbed buffer because he refuted it and said, no, it's not. Yes, it is. It's natural undisturbed. We've lived here a decade. We built the home. Unfortunately, I was home alone that day, and the neighbor had another unknown person, a gentleman. They're both rather big gentlemen, and they became very confrontational and very aggressive, and I got very, very scared. And when I asked them to please back off, they became more aggressive and started to approach me. So I did, for the first time ever, call the City of Smyrna Police Department, and they did respond.
And eventually, did you notify code enforcement of this issue?
Absolutely.
And what was their response?
That they would check into the situation.
And after checking into the situation, did you hear an interpretation from them initially?
Yes, that the fence could be erected and the trees, some of the trees could be removed.
What about the underbrush?
No, the underbrush was not supposed to be removed.
But was it their interpretation that it could be removed?
If it was diseased or under those types of circumstances, I would expect it, yes, sir.
And are you certain that over the last couple of years that trees and underbrush and other foliage have been removed from the buffer?
I am absolutely, positively sure. And if you look at the photos, it's prima facie evidence. There have been many trees. The tree removal started way prior to code enforcement being involved. Way prior to me getting code enforcement involved.
I want to show you what we've marked as Exhibit 6. Seen that photo before?
This is not my house.
Is it your understanding that that was taken by code enforcement on one of their visits to the property?
I would assume code enforcement took this photo.
And what does the photo, the top photo, represent?
It represents my fence line on the side of my house, which abuts the neighbor's backyard.
Right. And where's your home in this photograph?
My home is behind this fence
Okay. And
on the other side.
is this area here the buffer area?
Yes, sir, it is.
Okay.
Yes, sir, it is.
And what do you notice about that picture?
I noticed that there's wheelbarrows, multiple bags of Quikrete, tools, buckets, all types of machinery. I see extension cords for electricity.
Now, this picture is dated in the bottom June of 2012. Is that right?
June 29th, 2012.
Okay. Was the buffer fuller than that prior to June 2012?
Much, much, much fuller.
How so? More trees?
A lot more trees along this entire tree line here.
Okay. Now I want you to look at Exhibit 7, another photograph here. Another photo taken by code enforcement. The top photo, what does that represent? Is that the same area?
That is the same area. My home sits back on the other side of this large fence.
Okay. And if you compare how the foliage looks in that photo to even the June 2012 photo, do you notice a difference?
Huge.
And does it appear to be a lot thinner?
Much, much thinner.
And certain foliage is not there anymore. Is that fair?
Oh, it's very fair and accurate. Yes, sir.
Now, you mentioned at some point a fence was placed inside the buffer. Is that right?
Yeah, that is correct.
Okay. And did you notify code enforcement about the fence being built?
Indeed, via the city's email.
And was their interpretation that the fence was okay, that they could do that?
That was their interpretation. The fence was okay.
What did the fence do to your views for your last 10 years?
Destroyed them. I mean, the views are gone. I'm looking at an 8-foot solid wooden fence.
Go back here to Exhibit 5. If you could hold that up and tell me what that picture represents.
This is now my home, and on the left side, you can see that I no longer have that beautiful, lush green space. I have 2 trees, and I have a big, large, solid wooden fence.
Now, is this the type of activity that you were worried about when you bought your home?
The fence was specifically my concern with Mr. Hatcher. I understood that with the size of space, another home couldn't go there. It was too small. But the fence was the first. We're already surrounded by fence where we sit because we sit up back on a hill. We're surrounded by 8 homes, and all the homeowners have fences in the backyard. So a fence was something that I thought, oh my gosh, if another fence goes up, I wouldn't want to live here. So we specifically asked Mr. Hatcher, what about a fence? And he said, nothing can be erected in the natural undisturbed buffer.
Did the city ever mention that this Section 503 was the basis of their conclusions that this activity was allowed?
Indeed.
And did you ever have an opportunity to review Section 503?
I did indeed.
To show you Evans Exhibit 9, which does that appear to be the Section 503?
Yes, sir, it is.
And what did you note about this upon reading it?
Well, the first thing that jumped out was actually in the first paragraph. It says, where any parcel which is zoned and used for commercial, industrial, utility, public, or similar purposes abuts a residential district or any other zoning classification as herein stipulated, a buffer strip or area shall be required on the common boundary line or lines between such differing classifications.
Is your property a commercial, industrial, utility, or public property?
No, sir. It's a residential division, zoned residential.
What about the neighboring Concord Walk property?
All residential.
So it's residential on residential?
Yes, sir.
Do you have any personal problems with your neighbor, Mr. Damarillo?
The only problem I have with my neighbor is the fence being erected. Prior to this, I didn't even know my neighbor.
And the trees being removed?
Well, the trees being removed. Until I knew the trees were being removed, until I started witnessing it, eyewitnessing it in the spring, then I knew definitively it was the neighbor removing the trees and the underbrush.
Is your dispute solely related to the disturbance of the buffer?
Absolutely.
Have you ever made any other complaints about Mr. Jamarillo?
Didn't even know his name.
Have you ever set foot on his property?
Never been on his property.
Have you ever thrown anything or dumped anything on his property?
Never.
How have you felt since all this started?
Victimized. Deceived. I feel like the city of Smyrna is remiss in enforcing a code that is very clearly written. I ask nothing punitively. I ask no monetary compensation. I've spent a lot of money. I've cried a lot of tears over losing that space in my home. And we simply want the natural, undisturbed buffer restored to the extent that it can be and have the fence removed. That is all we are asking for. We would like our home restored to the condition that we have enjoyed for a decade there.
That's all the questions I have. I'll tender Mrs. Evans for any questions from the board or the city.
I don't have any questions for her. We can take questions from the board.
I don't have any.
And you kind of mentioned this, but just I'll have you restate it again. I did want to ask you, what is it that you were seeking from this particular board?
I'm seeking the board to right a wrong. I feel as if though, not with any malice or forethought, the city has wrongly applied and interpreted this code. I'm asking that you please recognize that the city has a responsibility, both legally and fiduciary responsibility, to enforce the codes the way that they are written. So I'm asking that they please look at this code and realize that it doesn't apply to this piece of property. As I said, I don't want to punish anyone. I'm not looking for any monetary compensation. We just simply want the natural undisturbed buffer restored to the extent that it can be now.
All right. Sorry, I have made some notes here to ask you. Okay. All right. Anything else?
I do. So currently, you have your own wooden fence on your own property that's adjacent to the neighbor's wooden fence.
Half of it. We only put half a fence in there. The fence starts at the back of the house.
Currently, you have a wooden fence adjacent to their wooden fence on part of the property.
Yes, sir. Yes, sir. It is quite smaller in size.
You know what type trees were cut out of the buffer?
Hardwood trees, oaks, sycamores, pin oaks.
What about the size in diameter?
I would say that the diameter of some of the trees were probably a foot. Very, very, very tall. Very, very, very lush.
What about underbrush? What kind of underbrush was removed?
Full of underbrush. I'm not familiar with the plants that are indigenous to that area, but there were a lot of small shrubs and underbrush that covered the entire piece of property.
Looking at Exhibit 4, you know the date of that photograph?
No,
the
sir.
first one of Exhibit 4.
I could guess for you, but I don't know the exact date. No, sir, I do not.
Go ahead and take a guess.
That wall we put up in 2000 and I want to say 5. So this was probably sometime in 2005.
Time of year?
Towards the fall, as evidenced by the foliage on the leaves there.
Are any of those trees on your property, or are they in the buffer of the adjacent subdivision?
They are in the buffer.
They're not your trees.
No, sir.
The fence on Exhibit 4, that one there in your front yard, whose fence is that?
This one here?
Uh-huh.
This is the lady that lives just to the right at the end of our driveway. If you take the driveway all the way up out of our home, there's a home to the right there, and that is her fence.
That's in your subdivision?
Yes, sir, in Hampshire Place, and that fence was there when we bought the home. She's the original homeowner there as well.
Exhibit 6. The top photograph. The fence to the left, split this photograph, the fence to the left. Whose fence is that?
That is my fence, sir.
Does it still exist today?
Yes, sir.
Bottom photograph of Exhibit 6. Exhibit 6. The fence to the left. Whose fence is that? The only fence on that photograph.
Not my fence. That's my fence is a picket top. My fence is a 6-foot picket top. That is not my fence.
So is that another area of the property?
That's another area of the property, but that is not my fence. The only reason I had a fence erected is when the police responded to my call, the officer suggested that I have a survey done on the property. So I did. I had a survey, and in doing the survey company informed me that the very corner of that fence was 4 3/4 inches over into the neighbor's property. Just the post, not the entire fence line. So I then tore down that fence and had a brand new fence erected so it would not be encroaching on anyone's property line. My homeowners association only allows a maximum of 6-foot height on the fence. So I put up a 6-foot fence there. Only after I discovered that the front post was 4 3/4 inches into the neighboring property, which I did not feel was right.
So what's the significance of this bottom photograph? What are you trying to show us?
There is no significance of the bottom photograph. That was just on the document that was produced by the city. The only photograph that we care about is the top photograph. It's the only one I think it's the only one you talked about. Is that fair?
It is fair.
So that fence we're looking at on the top photograph on the left is your fence. And how far is it off of the property line of your adjacent neighbor?
It's on my property line.
Completely in your property.
Completely in my property, yes.
So the area between your fence and I assume this fence to the right is your neighbor's fence.
Yes, sir. I believe that is the fence that was originally constructed with that home. There's probably been 2 or 3 owners of that home in the 10 years that we've lived there, and that fence was there when we bought the home. The builder put it up with the home, and it remained for 9 years or so.
So the area where the bags of cement are, that's
The buffer.
somewhat the buffer area.
Yes, sir.
I'm good right now.
I have a question about, since we're on that same photograph, the fence on the right side of the picture at the top of Exhibit 6, has it been removed?
Yes, sir.
Okay. Where in that photo is the new fence? Where would it be? Because it's not in here. I mean, would it be where the bags of concrete are?
It would run where you see my fence on the left. It runs all the way across my fence, plus an additional, I don't know, maybe 10 feet. And then it's pushed further back out and comes all the way through here.
So the majority of the fence that exists now, that has been erected, is right behind your fence.
No, sir. Most of the fence that's been erected is right in the middle of the buffer zone, running perpendicular to my fence.
Okay.
So if your fence is on the property line, their fence is 10 foot into their property, so, because you just said the middle of the buffer,
I think
right?
she meant where
So
it turns.
you got a 10-foot space in between your fence and their fence?
I can't judge that distance from here. I've never been back there.
Not according to the photograph, but you live there. How much distance is there between the neighbor's fence and your fence?
The new fence or the old fence?
The new fence.
Butt to butt.
But at some point,
That's about 8 to 10 inches.
Okay, so
8 inches.
So the new fence is not in the middle of the buffer.
but at some point it turns 90 degrees. Is that what you're saying?
Yes, sir. Originally, there was no fence that far. The only fence that was existing was this. They tore this down, put up a fence straight across the back of their property, and then they brought it, Exhibit 5, all the way through the buffer zone.
Okay.
But let's clarify through the buffer. Through the buffer, I mean, how much of their fence is in the buffer then?
All of it.
No, well, if the buffer is what, 20 foot, how much are they into the 20 foot with their fence?
Lengthwise,
Widthwise?
as far as I can tell, looking at the plats, the fence is smack dab in the middle of the buffer zone.
So they're approximately 10 feet into the buffer?
Yes, sir.
Okay. Your fence is not, is
Nowhere
your fence
near the
adjacent to, so your fence is on the property line. It's adjacent to the buffer. So there should be a 10-foot gap in between your fence and their fence.
At least.
Okay. So looking at Exhibit 7, let's make it easy, go up the top photograph. There's some kind of little 4-foot, 3-foot, 2-foot picket fence in their backyard, and then you've got the big, looks like maybe an 8-foot opaque wood fence. 10 foot from that fence toward your house, your property line, is your fence. So I'm looking at half the buffer up here then, right?
I think I've been there, and maybe I hopefully can clarify and she can confirm, but I think their fence on the back is only about this far from her fence, which is
It
on her
is.
property line. So their fence is on the edge of their property line in the buffer, on the edge of the buffer.
I'll tell you what will clear it up, Scott. In Exhibit 7, where in that picture does your fence come behind the fence that we're seeing?
My fence comes behind the large 8-foot fence and runs parallel to it, but my fence stops at the back of my house. We didn't carry it all the way through.
Okay,
So-
since we don't know where your house is in this picture, where in this picture is your fence? Does it go behind all of that except for the bottom right hand? That's what I'm driving at. What part of this picture do you actually have a fence that abuts this fence?
From the back of this corner all the way to our fence ends about right here.
Okay.
And the other fence, the 8-foot fence, and remember mine is just a 6-foot, that's all I was allowed. Their 8-foot fence continues to run another 10 or 12 feet.
And then turns down their side yard, I guess.
Well, actually, it was the way they built the fence. They built the fence around the green space, and then they just added an additional piece of fencing straight across my property line.
But I think what they're saying is it turns 90 degrees and comes
Yes.
so through the buffer.
Yeah, and you can see it in this one, in Exhibit 5. You'll see the end of their fence because this is the back side. You can see the 2x4s, and then when they started going into the buffer, they flipped it around. So you'll see it ending here and then turning 90 degrees and then coming back and meeting the neighbor's home, the side of his home.
So to clarify, your fence, they erected a 8-foot fence along their rear property line, which is your rear or side property line, and there's a small gap between your fence and their fence. So most of the buffer is, the fence really isn't through, it's along the edge of the buffer.
I believe it's in the buffer.
Well,
Of course it's in it because you can't, but I'm just saying you got a small gap between your fence and their fence. So their fence is along the back end of the buffer, and then most of the buffer is basically hidden by their fence, but in this gentleman's backyard.
Yes, sir. Yes, sir. That's precisely it.
Is it accurate to say that the buffer starts at your property line and goes 20 feet towards the neighbor's house?
Yes, sir.
So he built it at the very rear of the buffer, right?
I'd have to get a tape measure out
But I
there
mean,
and see.
it's not 10 feet into the buffer. If the buffer starts at your property line and this fence is 8 to 12 inches away, it's not 10 feet into the buffer. It may be a foot into the buffer.
Their fence is not 8 to 10 inches away. I mean, their fence is 8 foot, mine's 6. And when I'm looking in my backyard, their fence is here, and I'd say there's about this much space between their fence and mine. And it's easy to identify because their fence extends 2 feet higher than mine.
See, okay, let me rephrase it then. If they built their fence 6 inches from your fence, then and your fence is on the property line, then they built that fence 6 inches into the buffer.
Yes,
Is that
sir.
accurate?
Yes, sir.
Okay.
Okay, any other questions? All right. This time we'll hear from, at this time we'll hear from an assistant attorney. Oh,
Place, did you want
Oh.
Mr. Evans?
Just briefly.
okay,
very
all
briefly.
right, go ahead.
Thank you.
Thank you.
Good morning, Mr. Evans.
Good morning.
Please state your full name for the board and spell your first name.
My name is Timothy Edward Evans. It's Timothy.
And you raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I swear.
Now, I don't want to retread all the ground we covered with your wife, but just from in your own words, please tell me about the 20-foot natural undisturbed buffer prior to 2012.
Well, the buffer was so thick of foliage and trees that you literally could not walk into the buffer. It had all kinds of shrubs, saplings, vines, and it was just very lush and green. Huge trees. Some of the trees were probably 40 to 60 feet high.
Now, at some point, you noticed the disturbance activities in the buffer?
Absolutely.
And when was that?
About the same time as my wife said, first of the year, it started to getting thinner, and then in April, my wife contacted me at work. I was at work and told me what was going on with the chainsaws, and the trees were coming down.
What have these disturbance activities over the last year and a half meant to you personally?
Well, it's disrupted our whole tranquil living that we've had for 10 years. It's emotionally wrecked both of us, and our little sanctuary back there is gone.
What do you hope to achieve today?
Like for the fence to come down, like for the buffer to be established as what it was originally meant to be. Most of the trees are destroyed. That buffer's probably never going to be back the way it was, but I'd like to see it go back to as close to its original state as possible.
All I have.
I don't have any questions for Mr. Evans.
Okay. Are we going to have Community Development Director Ken Sudder speak? Okay.
All right, thank you. If I could have Ken Sudrith come up to the podium, please. Ken, if you'll raise your right hand. Do you solemnly swear that the testimony you give in this matter should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Now, we know the board knows who this witness is, but for the record, please state your name.
Kenneth S. Sudrith.
Ken, if you could speak into the microphone, this is being recorded.
Kenneth S. Sudrith.
And spell Sudrith for the record, please.
Suddreth.
And describe, tell the board about your employment. What is your job?
I'm the Director of Community Development.
For the city of Smyrna?
Yes.
How long have you been with the city of Smyrna?
Approximately 6.5 years.
And what were you doing prior to that?
I was the Planning Director for the city of Duluth, Georgia.
And then prior to that, what were you doing?
I was the Assistant Planning Director for Athens, Clarke County, Georgia.
So have you spent a substantial portion of your career in city administration?
Yes.
So you're familiar with the task of having to interpret city ordinances and statutes, is that correct?
Yes.
So describe in your capacity here as the Community Development Director for Smyrna, how do you go about the process of interpreting a zoning ordinance?
First of all, if it's not specific, that's what we look for, is specificity to start with. If it is a general statement, then we look for past decisions and how certain things were handled. We would also read through the ordinance to see if references were made elsewhere to something similar in the ordinance and how that is being handled at that point. So it really can be a combination of several things depending on what we have to deal with.
All right, and the property at issue today is 3901 Concord Walk. What is the current zoning category applicable to that property?
It's an RAD classification.
Is it RAD conditional?
Yes.
Can you explain for the board how the RAD conditional zoning classification works?
Yeah, RAD is a classification that is applied by request as a rezoning. It basically stands for residential attached and detached structures, and the conditional aspect of that means that there were additional conditions applied to that rezoning when it was approved.
So the conditions when the zoning is approved become part of the zoning, become by extension part of the zoning ordinance itself as applied to that property, right?
That's correct.
Okay. How do you go about with one of these RAD conditional zonings? How do you go about finding what the exact conditions applicable to it are?
But there'd be a zoning file on the request, and so we would start there by pulling that file and reading through what was in the file, what the reports were in the file, as well as the minutes.
So who from your office's staff first became aware of a question arising as to the interpretation of the zoning ordinances applicable to this property?
Rusty Martin.
And who is that?
Rusty is our senior planner.
And then did he report the nature of this question to you?
Yes.
So what did you do then in terms of determining what the specific zoning conditions applicable to 3901 Concord Walk were?
Well, that's, obviously we pulled the file and went through everything that I've already mentioned, had a discussion about it, and given the information that we had, and then we proceeded accordingly.
And proceeded how? What did you do, or when did you first yourself have a look at this property?
Well, I personally didn't go out there until much later, but I asked Rusty to go check this out. I also brought in our co-compliance lead marshal, Tim Hardy, involved in this, and they went out and investigated and then reported back to me.
So did you then go back and look at the exact stipulations relevant to this property to determine if there had been a violation?
Yes.
All right. So if I can, since this is a question of Mr. Sudrath's interpretation, if I can call all of your attention then back to the Evans's Exhibit 2, which is the minutes of the meeting, the mayor and council meeting of March 18, 1996. And Mr. Sudrath, if I can have you look at some passages on here. And Mrs. Evans has already read in some of this, but I just want to go through this with you again. So since this has to do with the process of how Mr. Sudrath and his office come up with their interpretations of what the exact requirements are. Mr. Clays called attention to Ms. Evans to the third page. Initially, a question was asked by, at that time, Council Member Pete Wood to the developer about a setback and what would happen with the trees. And then Jim Hawkins followed up something. So what was your understanding of what the commitment of the developer was at that time?
The minutes indicate that Mr. Thompson, quote, Mr. Thompson stated he would work with the property owners and provide some type of buffer between the properties and will attempt to save as much vegetation as possible to provide a visual buffer between the properties.
Okay, but in that discussion between Mr. Thompson and Mr. Hawkins, they did not specifically state in that discussion that there would be a 20-foot undisturbed buffer, did they?
That's correct.
And so, based on that, that's not the part that's really applicable, right? What becomes part of the zoning are the stipulations themselves as adopted by mayor and council. Is that correct?
Yes.
All right. So if everybody will turn over one page, then. So which of there are, I think, and I'm not trying to testify for Mr. Sudreth, but there are 10 stipulations here. Which one is applicable to this property, or which one is applicable to the question before the board today?
Be condition number 8.
And so what does condition number 8 state?
The buffers will be provided as agreed to by Mr. Bradley Thompson, i.e. a 20-foot undisturbed buffer from the right-of-way of Concord Road for those houses which abut Concord Road, and install some type buffer between the rear yards of the newly constructed home where they abut other residential properties.
All right. Mr. Sudreth, if I can call your attention to Evans Exhibit 3, which is the plat of this property, and this is very small, so everybody will have to take a close look, which of the lots on this plat are we discussing right now?
Yeah, let me.
If either one of us can see it, that's going to be a miracle.
I think that's labeled lot 69, maybe.
All right. And does that lot abut Concord Road?
No, sir.
Could you read again the first independent clause of stipulation 8? By independent clause, I mean going up to the semicolon.
The buffers will be provided as agreed to by Mr. Bradley Thompson, i.e. a 20-foot undisturbed buffer from the right-of-way of Concord Road for those houses which abut Concord Road.
And again, does this property that's in question, does it abut Concord Road?
No.
And so then read the second independent clause of stipulation 8.
And install some type buffer between the rear yards of the newly constructed home where they abut other residential properties.
All right, so as agreed to and passed by mayor and council in March of 1996, was it a stipulation of this rezoning to RAD conditional that every property in this development have a 20-foot undisturbed natural buffer?
No, sir.
What was the commitment with respect to properties that didn't abut Concord Road?
That they install some type buffer between the rear yards of the homes that abut other residential properties.
All right, some type buffer. Now, let me have everybody look again at the plat that's recorded there in the plat book and the Cobb County records. This is a public record, but it's Evans Exhibit 3. We were looking at it before. What is the date on the plat?
March 6, 1998.
Is it normally when you're looking to interpret the city's zoning code, does a subsequently recorded plat have the effect of making an amendment to a zoning?
No, sir.
So when the developer of this property recorded his plat, the plat and the development as developed, in fact, was in accordance with zoning stipulation number 8. Is that correct?
Yes.
But the fact that the plat was recorded, even signed off by the city, as being in accordance with the zoning, did not in itself make the 20-foot undisturbed buffer a part of stipulation number 8, insofar as this property did not abut Concord Road. Is that your interpretation?
Yeah. Excuse me. Yes.
So what does stipulation number 8 require for 3901 Concord Walk?
Install some type buffer.
So a no disturb buffer was not in the zoning a requirement for this property. Is that correct?
Correct.
Is there some type of buffer here?
Yes.
Does the zoning code allow a fence to be some type of buffer?
Yes.
What about the fact that the plat says otherwise?
We would go back to what was actually approved. In this case, it would be the minutes.
Did the property owner of 3901 Concord Walk get a permit for his fence?
Permits for fences are not required.
Hypothetically, Ken, if the work that was done in the area between the Evanses' property and this person's property at 3901, if it had, prior to it being undertaken, if it were going to violate one of these stipulations, would it have been subject to the normal variance application process? Could the homeowner have applied for a variance to do this?
Because they are conditions that are decided upon by mayor and council, if there's a variation one being requested of that condition, it has to go back to mayor and council.
Okay. But mayor and council could themselves vary a formerly agreed to stipulation. Is that correct?
Yes.
Has any such variance on any properties in the city, to your knowledge, ever been granted where one or more adjacent property owners opposes the grant of the variance? Can I restate that so that you can understand my question? Since you deal with the matters of variances and property, when someone applies for a variance here in the city and it has to go to mayor and council, has the mayor and council ever granted a variance where that variance was opposed by a neighbor?
I'm sure there's been many requests that have gotten to council, but I'm sure they probably had people oppose, and they approved the request.
If we can look back, and now if I can just call your attention now to the Evans's Exhibit 9, which is Section 503 from the zoning code. You would agree with the contention of the appellant here that by its strict terms, this provision only applies where residential districts abut industrial or commercial type districts. Is that correct?
Yes.
And so by their contention is correct that by its strict terms, this buffer strip requirement in this provision is not applicable to these two properties. Is that right?
That's correct.
So as between two residential properties under the city's zoning code, what is the normal buffer strip requirement?
We do not require any buffer strip between single-family residential uses.
But if it's made part of a rezoning stipulation, then it would be required. Is that correct?
That's correct.
And just to repeat, and not to get too repetitive, but in your interpretation of zoning stipulation 8 as determined by mayor and council, what was required between these two properties?
That they install some type buffer between the rear yards.
And is there even now, after the work has been done, is there some type buffer there?
Yes.
All right. Thank you, Mr. Sudworth. I don't have any more questions. Sure.
Sorry.
Morning, Mr. Chairman. Is it still morning? Morning. So when the owner of a property in the city wants to have their property rezoned, they submit an application.
Yes.
So essentially what they're doing is they're applying to amend the zoning ordinance.
Sir.
Pardon me, can you make sure you speak into the mic, or you can get the handheld
I'm sorry.
if you want to.
I'm sorry. Let's see if we can put it in the middle there.
Would you prefer the handheld so you
If it works.
Yeah, it's right.
Y'all getting that? All right. Good deal. So I guess I'll start over. So you probably couldn't hear me the first time around. And so when the owner of a property wants to have their property rezoned, they submit an application. Is that fair?
Yes.
And they're applying to amend the zoning ordinance and the zoning map, right?
Yes.
Okay. I want to show you what we've marked as Evans Exhibit 10, which is in here. There we go. Now, I'll represent to you that I printed this off of MuniCode yesterday, and MuniCode's a place where the public can go to look at the city's ordinances. Is that fair?
Yes.
Okay. And correct me if I'm wrong, but this is Article 15 entitled Amendments that contains the regulations applicable to zoning code amendments. Is that right?
Correct.
And applications, after they're submitted, they're reviewed by staff, and then they go to the Planning Commission for recommendation, and then they go to City Council for decision. Is that fair?
Correct.
Now, if you turn with me to Section 1508, you see that?
Yes.
Now, that sets forth what the City Council is required to consider in considering an amendment. Is that right?
Yes.
Okay. And the second condition says whether the zoning proposal or the use proposed will adversely affect the existing use or usability of adjacent or nearby property. Did I read that right?
Yes.
So the effect of what a rezoning is going to have on surrounding property owners is an important consideration for the council. Is that fair?
Yes, it's one of multiple conditions they look at.
So would it be typical that when someone applies for rezoning and that zoning is approved, that there will be a condition which is attempted to benefit the adjacent property owners? I strike that. Not to benefit, but to reduce the negative impacts of the rezoning on the adjacent property owners?
That's often the case if it's necessary.
And the applicant, if it's approved subject to conditions, the condition's essentially a part of the zoning ordinance. Is that fair?
Correct.
And you discussed with Mr. Tucker there that the property at issue was rezoned in '96. Is that fair?
Yes, it is fair.
And then it was a fellow named Bradley Thompson, who I guess was the developer at the time, applied to rezone from R20 to RAD zoning.
Yes, that's what it indicates.
And you've reviewed the minutes. You just looked at them. Now, is it common at rezoning hearing for the city council members to ask questions of the applicant?
Yes.
And in the minutes, it talked about Councilman Hawkins asking Mr. Thompson about the buffer requirements for the abutting residential properties. Is that right?
Yes.
And in doing so, is it possible that he was trying to figure out what this rezoning process was going to have, what effect it was going to have on the neighboring property owners?
I can't tell you what was in the gentleman's mind when he asked the question.
I mean, is there any other reason why he would be asking that question?
Obviously, that might be one of the reasons, but I don't know the exact reason why that question was asked.
Now, if you look at the minutes there, I think it's exhibit number 2. And you go to condition number 8, and forget the first part of condition number 8. We acknowledge that this property is not on Concord Road. That doesn't apply. But the second condition says the buffer will be provided as agreed to by Mr. Thompson, and he'll install some type of buffer between the rear yards of the newly constructed home where they abut other residential properties. Is that right?
Yes.
Okay, and if you go back to when they talked about it, and he says he will attempt to preserve as much vegetation as possible and provide a visual buffer between the properties. Is that fair?
That's what it says, yes.
It doesn't say anything about fence, does it? It says visual buffer, preserving vegetation.
Yes.
And then we also looked at the plat, which was Exhibit 3. And that says 20-foot natural and undisturbed buffer on it, correct? Around the rear yards of the properties. And if you look at the second page, it's blown up so you can read it a little bit better.
Yes, it says 20-foot natural and undisturbed buffer.
Okay, and that plat was signed off on by the city, correct?
Yes.
And the developer, when developing that subdivision, had to adhere to that plat. Is that right?
Correct.
I mean, he couldn't just go build not in accordance with the plat. Is that right?
The issue on that question is, yeah, the plat needs to be followed, but if there are requirements that they have exceeded what the minimums are, and indicate that on the plat, it doesn't replace what the requirements were. It just means that they've met those requirements.
Okay, so it's your position here today that no undisturbed buffer was required for this property. Is that right?
That's correct.
Okay. But there was a buffer requirement, right?
Some type of buffer, yes.
Okay, and when you say some type of buffer, that's a fence. That can be a fence.
Yes.
And has Mr. Jamarillo, the owner of the neighboring property, ever applied to take trees out of that zone? To remove trees from the buffer?
Yeah, again, we don't issue permits for fences, and residential property on an individual property line that doesn't have to get permission to take trees down.
Okay, but there was email communication between code enforcement and Mr. Jamarillo where he would say, I want to take these trees out. Will you come out and look at them to see if I can take them out? Is that fair?
That's correct.
And the city would go out and they would look at them?
Yes.
Is that right? And if the trees were in the buffer, they would tell him he couldn't do it. Is that fair?
If we felt they were in the buffer, because the requirement says some type of buffer, I can't tell you that we wouldn't approve some trees coming out of what we felt was a buffer, depending on how the buffer was, what was in the buffer to begin with. There are multiple reasons trees might need to come out. They could be diseased, they could be leaning, they could have been, damaged in a storm. So I'm not going to say that we would say, well, you can't take that tree out.
Okay. To your knowledge, has the city ever told Mr. Jamarillo, you cannot remove this tree out of the buffer because it's an undisturbed area and it's a healthy tree?
I've never spoken to that gentleman, so I'm not sure that I can answer that question.
See if I can find it here. I'm going to show you what we've marked as Exhibit 16. And this is an email from Mr. Jamarillo to Rusty Martin. And actually, I strike that. It's to Mr. Jamarillo from Rusty Martin. And if you read the email, it says, the tree appeared to be in the 20-foot undisturbed buffer. If that is the case, the tree cannot be removed unless it is deemed to be diseased, dying, or a hazardous tree. Let me know if you need any further information. Did I read that right?
Yes.
So Mr. Martin, at one point, had told Mr. Jamarillo he can't take trees out of the buffer because it is an undisturbed area. Is that right?
Yes.
Okay, and so what you're here saying is that a fence is the only buffer that there was on this property. If that's the case, why is he telling Mr. Jamarillo that?
No, that's not what you've mischaracterized what I said, sir.
Okay, well,
I didn't say a fence was the only buffer.
Okay.
I said that a fence could serve as a buffer.
And that email indicates that as far as Mr. Martin was concerned, there is a 20-foot undisturbed buffer on the property. Is that right?
Yes.
Okay. But it's okay. The fence is sufficient now.
I look at the fence, that the fence was added as a supplement to the buffer. Again, the requirement is some type of buffer. That is up to the discretion of who's reading that at that point in time, and that falls to the director in this case. So yeah, there could be trees that can come out of some type of buffer. What Rusty was saying here is, yeah, that's what's on the plat, and yeah, we don't want you taking that out, but that doesn't mean that substitutes, that the plat overrules what council approved.
Okay, so it's fair to say there have been varying interpretations of what the buffer actually is in this case by the city.
I don't think there has been varying interpretations of the buffer. I think they supplement each other.
Okay, so why, if a fence was some type of buffer and that was the only requirement, why is Mr. Martin telling Mr. Gemarillo he can't take trees out of the buffer? Does that make any sense?
Yeah, we were trying to work with the property owners during this, what we feel is a neighborly dispute on that, with that. Now, if, how this is worded, to me, it is not in conflict. We are trying to manage that situation, and so yes, we had said we don't want you taking the tree out, but that doesn't mean you can't take the tree out.
Okay, so Mr. Gemarillo, if he'd have cut that tree down, there's nothing you would have done about it, even though Mr. Martin told him not to do it?
Given what again, I can't tell you unless that actually occurred and we went out there to determine what was remaining of the buffer, because it says some type of buffer. It doesn't say 20 feet. It doesn't say undisturbed. It doesn't say it has to have 10 trees in it. It doesn't say it has to have undergrowth in it. It says some. So we would have to, if indeed he took the tree out, we would go out and make that determination. Is there still something there acting as a buffer?
And Mr. Martin called it in his email the 20-foot undisturbed buffer, did he not?
Yes.
Okay. Is it fair to say that a fence is a structure?
Yes.
And a structure, by definition, has to be erected or constructed. Is that fair? It doesn't occur naturally.
Correct.
Is it also fair to say that erecting a fence is a disturbance of the property it's erected on?
I'm not sure I would categorize it as a disturbance.
What does the term disturb mean to you?
That you have changed you've changed an area.
And if by installing a fence, haven't you changed the area in a place where a fence didn't exist before?
You have added again. This is an interpretation issue where adding a fence, whether you believe it's disturbed or not, is an interpretation issue. They've added a fence to the perimeter of the buffer that started at the property line, which is what we are going on, is that some type of buffer is required. The plat indicates, yeah, they're going to put in a 20-foot natural and undisturbed. Obviously, they're starting it from those property lines. So they put the fence along that property line.
And by placing the fence on the property line, they disturb the area. Is that fair?
You have to go in, and yes, to put the post in, you have to dig a hole. And if you want to classify that as being disturbed, yes.
Okay.
But we're unaware, I'm unaware of any trees that had to be taken out to get that fence in.
And you testified here today that Section 503 is inapplicable to this situation. Is that fair?
Yes.
Has that always been the city's interpretation?
We use 503, as I stated earlier, to when Mr. Tucker asked me how we make interpretations, is we go back through all documents to see what has already been decisions that have been made. There's no question that 503 applies between residential and a non-residential property, be it commercial or industrial aspect. But within that section, the city has already indicated it says you can use a fence to act as that buffer if need be. My point is even though it's not applicable to the specific case, it does demonstrate that the city, by its own words, will consider a fence as within that buffer, as part of that buffer, to meet the requirement.
But as we discussed, it only applies to commercial, or strike that, it only applies between non-residential and residential abutting properties, right?
That's correct.
And by applying it to this situation, you're extending it beyond its plain language. Is that fair?
We're not applying it in the sense that that's what is triggering the requirement. We are saying that the city itself has in its regulations that a fence can be used.
I'm going to show you Exhibit 13, which is another email. This email is from Russell Martin, which I assume is Rusty Martin to you. In fact, he signed it, Rusty, and then you responded. Let's read what it says. Now, this is an email of Rusty interpreting the situation. It says, when Tim and I visited the site, there was no evidence that any trees had been removed from the buffer. We spoke with the property owner, and he explained that he cleared some underbrush and overgrowth in the buffer, but did not remove any trees. Per Section 503 of the zoning ordinance, the removal of underbrush and overgrowth is allowed. So it's fair to say that Mr. Martin was applying Section 503 to this situation. Is that right?
In that regard, yes, but it's because of past examples when that section was triggered, that was allowed because of past decisions, and so that's why that was referenced.
Yeah, but again, that code section by its own terms does not apply to abutting residential properties, correct?
That's correct.
And these are both residential properties. There's no dispute about that. Is that right?
That's correct.
Now, I want to go down to Section 503, which is Exhibit number 9, see if I can find it in this mess that I've created. I apologize for this brief delay. Okay. If you go down to the 4th paragraph, it says, and this is talking about the buffer requirement, or the buffer strip as it's called here. It says, said strip shall be planted and maintained in a healthy, growing condition by the property owner. No such buffer strip shall, however, extend nearer to a street right-of-way line than 12 feet. And then the following paragraph says, where the conditions described in the preceding paragraph cannot be met with respect to the required 10-foot buffer strip, the owner of said buffer area may erect a permanent or opaque fence not less than 6 feet in height. So under 503, in order for a fence to be erected, the buffer must not be able to be maintained in a healthy growing condition. Is that right?
Well, it's where the conditions can't be met. I think it's a better way. I mean, this says where the conditions described in the preceding paragraph cannot be met. You said in a healthy, this says maintained in a healthy and growing condition by the property owner.
That's in the preceding paragraph, correct?
Yes.
So if that condition can't be met, then you can put a fence up.
Correct.
Okay. Do you know if there was any investigation or evidence to see if this buffer couldn't be maintained in a healthy growing condition before the fence was erected?
Yeah. People from my office were out there. Yes, sir.
And do you know if that determination was ever made, that this area cannot be maintained in a healthy growing condition?
No, I don't think we ever determined it couldn't be maintained as a...
Okay. And Section 503 also limits the fence to 6 feet in height. Is that right?
Yes. It says not less than 6 feet in height.
Not less than 6 feet in height. Okay. How do you define underbrush?
It's just the natural occurring understory that occurs in an area.
And under 503, is it the city's position that it's okay to remove underbrush from a buffer?
It says, except as provided of, the natural topography of the land shall be preserved, and natural growth shall not be disturbed beyond that which is necessary to prevent a nuisance or to thin such natural growth were too dense for normal growth, or to remove disease, misshapen, or dangerous or decayed timbers.
Does it say anything about underbrush in there?
So it shall be preserved in natural growth. I mean, natural growth is
Underbrush.
it can be
underbrush.
underbrush, yes.
But it doesn't say you can take it out just for the heck of it, right?
Well, it has to be related to one of these other issues that I've already mentioned.
Right. It has to be growing too fast or preventing the natural growth conditions. Is that right?
Correct.
And you don't know if that determination was ever made before the city condoned the neighbor removing all of that stuff from the buffer. Is that fair?
Yes, I guess that's correct.
Okay. Now, under the zoning ordinance, if two provisions deal with a similar subject matter, the more restrictive provision controls, correct?
Normally that's the case, yes.
And if you build a structure that violates the zoning code, each day that structure stands, that's a new violation. Is that fair?
Technically, they could be cited on a per day. Whoever, if there is a violation by someone, we technically have the authority to cite on a per day basis, yes.
Now, you discussed the variance process a little bit with Mr. Tucker. There are a number of criteria that someone must meet to obtain a variance. Is that fair?
Yes.
I mean, I'm not going to, I know you don't have the code section in front of you, and I'm not going to ask you to recall them specifically, but if you can remember generally, what are they? Unnecessary hardship, is that one?
Yeah, there's a list of about a half a dozen conditions that we ask at a minimum that people demonstrate to us, and yes, that it is a hardship that the literal enforcement of the ordinance presents an undue hardship to somebody.
Okay. And in this case, did Mr. Gemarillo, the property owner, the adjacent property owner, did he ever seek a variance for his fence or to remove the trees?
No.
And you talked about that on some occasions, city council have gone ahead and granted variances that have been opposed by neighbors, and you said that probably happened?
Yes.
And is it the converse also true, that probably the city council has denied variances that have been opposed by neighbors before?
Yes.
Okay. That's all I have. Nothing further.
Before y'all answer, can I just clarify something, because there have been questions about what Rusty Martin has said in his emails. Ken, if you'll state again, what is your position with the city?
I'm the director of community development.
And what is Rusty Martin's position with the city?
He's the senior planner.
Is he in your department?
Yes.
Are you his superior?
Yes.
Are you permitted to overrule interpretations he makes of the city code?
Yes.
Let me call your attention again to Evans Exhibit 12. And this is in the zoning code itself. If I can have you look at Section 1700, who is vested with the authority to make interpretations of the zoning ordinance?
The director of community development is.
And is that you?
Yes.
All right. Nothing further for me.
I just have one brief question, if is it okay? In the email that we looked at earlier, let's see if I can find it here. This is Exhibit 13, when Mr. Martin was telling you his interpretation and saying that Section 503 applied and whatnot. He responded, "Got it, thanks." Is that correct?
Yes.
You didn't tell him you're wrong. 503 doesn't apply for this reason, which you've testified here today. You need to get this right before you go back to the property owners.
No, I just said I have received it. I haven't indicated that it's been read or analyzed. I just said I've got it, so he knew it was received.
Do you know if Mr. Martin or anyone from code enforcement has ever gone back out to Mr. Gemarillo and said, you know what, the fence line is some type of buffer, that's okay, you can go ahead and cut all those trees you wanted to down now?
I'm not aware
Okay.
of such.
No, nothing further, thank you.
Okay, any questions for Mr. Sudworth?
I got a few. Mr. Sudworth, who appoints you to your position in the city?
I am hired by the city administrator.
Okay. Are you appointed by the city council?
Normally, the process is that you are recommended by the city administrator and approved by mayor and council.
So you are appointed by the city council?
I guess indirectly.
Okay. Ultimately, are you hired to carry out what they say to do?
Yes.
Okay. Referring to the minutes from the meeting, well, before we get to the minutes of the meeting, let me ask you, in your profession, throughout your career, elsewhere in here, is it common practice for you to attend city council meetings and hear all sides with the city council and explain to the city council about a new subdivision going in place and all the stipulations for long periods of time sometimes, and then watch the city council make their final decision?
Yes.
During those discussions, is there often a lot of things that are brought up during the discussion that are not reflected in the final decision?
Yes.
Okay. Is it your job to enforce everything that was discussed during there, or is it your job to enforce what the final decision of the city council was?
Final decision.
Okay. Do you have the authority to enforce anything other than their final decision?
No.
Does Rusty Martin?
No.
Okay. So if the city council lays out stipulation 8, specifically the part that applies to this, and says some type of buffer, do you have the authority to enforce any other thing besides that?
No.
Can you enforce a 20-foot buffer?
No.
Can Rusty Martin?
No.
Okay. Thank you.
You got any questions, Scott?
Well, I mean, I'd like to talk to Rusty.
If Mr. Clays doesn't have any objection to that, we'll swear Rusty Martin and let him answer questions. Okay. That's fine. Rusty, if you'll raise your right hand, you solemnly swear the testimony you give in this matter to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Step up and just state your name and occupation for the record, please.
I'm Rusty Martin. I'm senior planner with the City of Smyrna Community Development Department.
I mean, are you aware that trees were cut down in this some type of buffer?
To go back, the first call we received was about removing debris out of the buffer and removing bricks. The second call we went out to the site was when they were erecting the fence and supposedly the trees were being removed. The only tree that I saw that was removed was a large pine tree. However, that tree, where the stump was and was grubbed and all that, was located outside the 20-foot buffer. And at that point, I hadn't done a whole lot of research other than looking at the plat and seeing that there was an undisturbed 20-foot buffer on site at that point. So Tim Hardy and I pulled the tape. We measured the fence locations and measured the location of that proposed tree. And at that time, we made a determination that there wasn't a violation.
And I guess most of the communications you had originally were based on the plat and not the official minutes of the council meeting.
At that initial point, yes, off the plat.
Okay.
I think he gets a chance. Rusty?
Yeah, sure.
Have you ever told Mr. and Mrs. Evans that Section 503 applied to the situation?
Microphone, sir. Sorry about that.
Have you ever told the Evans that Section 503 applied to this situation?
Yes, sir.
Okay. And as you heard Mr. Sudra say, that was wrong?
I don't know if he said that was wrong, but...
Well, he did say... I'm sorry, go ahead.
I mean, obviously there's two different scenarios. There's during construction, and then there's the maintenance of a buffer and taking care of it. At that point, I was just reviewing it based off the question of what was going on and whether or not there was stuff being removed and how that was applied, because it's not stated or handled anywhere else in the zoning ordinance, and it's not directly stated how it needs to be handled in the zoning stipulation either.
Okay. But Section 503 by its own terms does only apply when residential and non-residential properties abut. Is that fair?
Yes.
You can look at it if you like. Let's review. It's right here.
Okay.
And you said initially that you thought there was a 20-foot undisturbed buffer on the property. Is that fair?
In the beginning, looking at the zoning, at the parcel plat, yes, it was reflected on the plat.
When did that opinion change?
Once this kept dragging out for however long, and we started looking at the zoning minutes.
Okay. How long ago was that?
I don't know.
I mean, was it in the last couple months? Or are we talking 6 months ago?
Within the last year.
Okay. And you've had subsequent communications with the neighbor, correct?
Yes, sir.
And you've advised him that he cannot remove trees out of the buffer area. Is that fair?
Since there was a question on whether or not what the buffer was and whether or not there's a buffer there, he had made a request because he had saw some damaged trees or diseased trees in his neighbor in that buffer area, and he wanted to confirm whether or not they were diseased or dying and whether or not he wanted to remove them.
And
Or he could remove them, I'm sorry.
And I'm sorry for interrupting, but there are certain trees which you went out there and you determined to be healthy, and you told him you cannot cut these down. Is that fair?
Yes, because they were close to the fence up there, and I understood the situation that was going on between both neighbors.
Okay. And that was recently when that happened, but back in April?
Yes, sir.
Okay. No further questions.
I don't have a question for Rusty. I do have another question for Ken Sudreth, though. Mm-hmm. Ken, could you answer one more question? Sorry about that. When the plat is submitted and approved and checked for compliance with the stipulations that the mayor and council put on this property, is it checked for minimum compliance? In other words, does this plat mean that when it's signed off, does that mean that plat meets at least the minimum requirements that the mayor and council put on the property?
Yes.
Okay. If a property developer submits a plat and they've exceeded some of those stipulations, does that now become binding?
No.
So even if that were to occur, do you have the authority to enforce what's on the plat, or do you have the authority to only enforce the minimum requirements that were placed on the property by the mayor and council?
Only the requirements that mayor and council placed on it.
So just for the record, one more time, do you have the authority right now, is it your opinion that you have the authority to enforce a 20-foot buffer between these two houses that we've been discussing for the last hour and a half?
No.
Okay, thank you.
Mr. Sudreth, before you leave, we're here regarding appealing your interpretation. Just can you explain to us again what your interpretation is and what your decision is regarding this particular issue?
The requirements on the property are determined by the zoning classification, and the conditions associated with this particular issue deal with I think it was condition number 8, which embedded in that, towards the end of that, was that some type of buffer had to be maintained on that. When the plat came in, again, you have to remember this is years before I was ever here.
Right.
But when the plat came in, the developer had proposed a 20-foot natural undisturbed buffer. I would assume that the staff at that point in time said, well, yes, that meets the requirement of some type of buffer. Mm-hmm. It doesn't become the law. It just means it's in compliance. Mm-hmm. It meets that particular. If he had come in and said something different, the developer had put something different on that probably would have been accepted as well.
And going back to what you said earlier, do you consider a fence to be some type of buffer?
It can be if nothing else is available, yes, a fence can be used to meet a buffer requirement.
Okay.
But it is my opinion, in this case, it's not. There are still trees out there.
Okay. Great.
So, to me, putting the fence up is still permissible. It supplements it. It doesn't replace it, but it's still some type of buffer. It doesn't describe that it can't have a fence in there.
All right.
I got one more question for you. I hate to play the what if game, but it seems like some of that's been done already. To bring this more current, because I'm clear that this happened way before you were here, but if we could bring this more to a current situation, if these stipulations, these conditions were placed on a zoning today, and number 8 was written the exact same way, the state of the property that's out there right now, is it your opinion that it would meet number 8?
Yes.
Okay, thank you.
Okay, are there any other questions?
I don't have anything further. If Mr. Clays wants to make a closing statement to you, he's welcome to. Or if the Evans want to say anything else to the board, they're welcome to.
Okay.
Yes, sir. I do appreciate your time today. But after listening to the testimony, I have to say that I still find the city not enforcing this condition egregious. A fence does not represent visual beauty. There have been many trees removed from that area prior to my contact made with Mr. Martin. I initially contacted Mr. Hardy, and when I didn't hear from Mr. Hardy, I personally made a visit to code enforcement and then began the email exchange. I want you to understand that there's nothing personal about this situation. It's been alluded to that this is a dispute between neighbors. In my mind, if I have a dispute with a neighbor, I'm going to go, my husband and I, and we're going to address the neighbor. I would never involve governmental agencies in a neighborly dispute. The only reason the police were involved originally is because I was alone and they were very confrontational and threatening. But under no circumstances is this a personal feud between my husband and I and people that we have never met before. This is simply about coming to a city that we had never lived in before, taking a builder that I know had a great reputation with the city and did a lot for the city. We've contributed to the city. We donate to the fire department, to the police department. We vote for SPLOS. We love our community. But with the city turning a blind eye to that being a natural undisturbed buffer that has been that way for 1 decade, 1 decade, 3 or 4 owners of 3901 Concord Walk, not one altercation, not one attempt to change the beauty that we enjoyed for a decade. So I'm just here to say that I simply am asking that the city enforce the code as it was written. If the speed limit on the road is 35 miles per hour and I'm doing 40, I expect the Smyrna Police Department to pull me over and to ticket me accordingly. I am only asking that the city of Smyrna do the right thing and enforce the code and the zoning as it was intended. They knew these residential properties were going to abut, and that was the entire genesis of coming up with this natural undisturbed buffer. So I thank you for your time today, and I just want to impress upon you, there's nothing personal about it. The only thing personal is that I've lost the beauty of my home, and it saddens me greatly. Thank you.
Okay.
And just to close, again, this is just a simple issue of interpretation, and I think, as you saw from the testimony, it was a moving interpretation throughout this entire scenario. At first, there was a 20-foot undisturbed buffer. and Section 503 applied. But 503, as was later discovered, only applies between commercial and or between non-residential and residential property. So now 503 doesn't apply anymore. And now there's no 20-foot undisturbed buffer anymore. Now it's just some type of buffer. This has changed periodically throughout, and as we keep attacking the basis of the decision keeps changing, and a new decision comes up, and a new interpretation based on new language. That's just simply not how it's done. As we saw, Article 15 of the zoning ordinance requires the city council to consider the interests of neighboring property owners when they enact conditions. And look at the minutes. They clearly reveal there was a discussion on this very issue. The developer readily agreed to a natural buffer. It was a condition of the rezoning. I mean, if you look at the actual minutes, it's discussed, visual, preserving as much trees as possible. But then you go to the conditions, and they're focusing on this last clause here. But the clause relates to the sentence before that, and the sentence says, the buffers will be provided as agreed to by Mr. Bradley Thompson, i.e., and then it talks about the buffer on Concord Road, which is not applicable. And install some type of buffer between the rear yards of the newly constructed home where they abut other residential properties. The buffers will be provided as agreed to by Mr. Bradley Thompson. That's what he agreed to do. He agreed to preserve as much trees as possible, and he followed through on that by submitting the plat and creating a 20-foot natural and undisturbed buffer. That was the whole point of this entire exercise. It's just, that's what it says. And if you're just going to enforce a condition, that's the condition. That's what you have to enforce. And then 503, I agree, completely inapplicable. It applies to residential and non-residential properties. It does not apply to the situation, even though that was what was the basis for so long. Now that's completely changed. You just got to enforce the condition as it's written. That was the intent. That was the reason it was written as that. You look back at minutes, and back then they didn't have court reporters, I don't think, at city council meetings. Everything, what's in the minutes is what's in the minutes. But I mean, read what's in there. And not every word that was spoken was obviously transcribed, but they felt important enough for him to say, yes, I will do that. I will preserve as much trees and green space as possible. And the city council said, yes, we agree. Adopt those buffers as agreed to by the applicant, which is what happened. The testimony is that a fence is some type of buffer. And Mr. Sudwith just said when he was responding to a question from the fire chief that if nothing else is available, it's some type of buffer. Well, here something else was available. A lush, natural, beautiful environment was available. It was completely unnecessary to come in with the fence. And if you look at 503, even though it doesn't apply to the situation, that's the intent of that provision as well. It says you can only build a fence when there's no natural growing area, which here there was. So it's just not what was intended. The city has never said that a fence is sufficient if there's a natural buffer, as there is here, which is what was in the minutes. We're just here because we think that the city council made a mistake. I do it all the time. It happens every day. 503 doesn't apply to this case. The minutes are clear as to what this is, and we're just asking the city to enforce it. We'll respectfully request that you reverse the interpretation and declare the following activities to be in violation of the buffer: the removal or disturbance of any healthy, naturally occurring foliage, underbrush, or trees, and the installation and existence of the fence, which is obviously a disturbance of the buffer. That's all I have. Thank you.
Nothing else for the city.
At this time, I'd like to make a motion, do we need to call for a public hearing? Since this is a public hearing, if anyone else would like to speak.
Yes, but I don't believe there's any.
Okay, all right. Well, at this time, I'd like to entertain a motion that we go into executive session.
So move.
Second.
It's been motioned and properly second that we go into executive session at 11:44 a.m. All in favor, please vote. All right, motion passes unanimously.
email here.
I've got all
I
of
got
Rusty's.
it. It's Mike Jaramillo is Jaramillo.
Back in the 6th grade. Sometimes I feel like that. Oh, no. No, it just happened. It was whoever happened to be sitting as the city clerk. Yeah, sure.
At our first rodeo.
Good heavens. Yeah, usually, well, I mean, it's variances. So anybody who applies for a variance, they can go up to through that process. But that's usually really simple. I mean, they don't usually go 2 hours on variance.
Sure.
And then alcohol violations.
Like someone sold underage.
Yeah, and that's pretty common because the city, the police department heavily dragnets that stuff, and so they'll go out, send in an underage informant to 15 different places, and they'll usually get half of them, and then the clerk that sold it goes to jail, and then we have a hearing on whether on any violation of the alcoholic beverage. The L&V board can impose any penalty up to revocation of the license. Now, that's not usually what they do unless there's been repeated violation. We have yanked the license before. Usually it's a year's probation and, say, 96 hours of no alcohol sales, which we always have wrap around a weekend. So they take some punishment for it. But that's what we have here.
Just out of curiosity, undercover who goes in, is it like a student or is it an employee? Or?
It's a high school student. Yeah, and it's always ultra obvious that they're not of age. They're carrying the new license that's positioned differently, and it has a red tab that says under 21. And it doesn't even look like your driver's license. It's turned around and all that. And the crazy thing is, in I would guess at least 25%, but maybe more like 50% of the cases, the clerk actually looks at the license. They look at it and hand it back and goes ahead and sells the beer. So,
What are they getting out of it? They're not making any more money by
no,
selling more beer.
they're not. But you know, all they're interested in is keeping up a volume of that stuff.
Scott on vacation.
Yeah, Scott's in Utah,
Is he hiking out there?
Moab, Utah.
Rock climber?
I don't know if Scott's pretty adventurous, so they may be doing some of that. I know they were going to do some biking and go rafting on the river and all. It's hot and dry there, I know that. Yes, yeah, it is. If you go, it's buried in there, but it says if anybody is dissatisfied with the final judgment of a city board, then you have 10 days in writing to put it and deliver it to Terry Graham, who's the city clerk.
Terry Graham?
Yeah, that all you have to say is you want to appeal the decision of the License and Variance Board granted on such and such a date. You know, so I mean,
Is it 10 days from today, or would it be 10 days from the date that the put in writing?
They'll go ahead and get it out in writing to you. You know, like I said, assuming that's what's going to happen, I would recommend putting it in writing, going on getting it to Terry, and then leaving a message or talking to Charles Welch, who's the city council member, saying, this is an issue going on in your ward. This is going to be heard by city council. We want to talk to you about it first. Normally the city council members will take it on themselves to advocate. Okay, that's fine. Normally the city council members will take it on themselves to advocate on behalf of people who are in their ward.
Okay.
Yes, that's Rosemary Rivera.
Make a motion we come back from executive session into regular session.
Second.
It's been motioned and properly second that we reconvene from executive session at 11:54 a.m. All in favor, please vote. Motion passes unanimously.
I'll start off. The board considered everything that was presented, and the board would like to thank everybody that put so much time into this, and we feel like it was very thoroughly explained, and we appreciate that. The board also is sympathetic to the situation that the appellant's in. However, we see this as a interpretation of the stipulations on the zoning, and the board agrees with Mr. Sudrith's interpretation of those stipulations.
I'll make a motion. We affirm the Community Development Director's interpretation of zoning conditions and requirements regarding the buffer land lot 241 Concord Walk subdivision. Make that in form of motion.
Second.
It's been motioned and properly second that we affirm the appeal of the Community Development Director.
Interpretation.
Let me see here.
He can restate it if you want. But.
That we affirm the appeal of the Community Development Director's interpretation of the zoning conditions and requirements regarding a buffer, land lot 241, Concord Walk subdivision, for Timothy and Terry Evans. All in favor, please vote. All right, motion passes unanimously, and I would like to let Mr. and Ms. Evans know that you can appeal this particular board's decision to the mayor and council. You can notify the city clerk's office, and that needs to be done within 10 business days, and she will inform you of what date this particular appeal can go on the mayor and council's upcoming city council agenda.
Can I clarify? Let's get this clarified for the record, and,
Okay.
and maybe maybe this will have to be restated.
Okay, state and speak in the mic, please.
What the board, and permit me for restating it, what the board is doing is denying the appeal and affirming the interpretation made by the Director of Community Development. Is that correct?
That is correct.
Okay.
And for the record, I can state that we are denying the appeal and affirming the director's interpretation. All right. Next item on the agenda is approval of the License and Variance Board meeting minutes of June 26, 2013. All in favor, please vote.
Wait a minute, let's make a motion.
Oh, I'm sorry. Yes.
Everybody's getting ready
I'd like
for
to
lunch.
entertain a motion, please.
Making a motion as board approve the License Variance Board meeting minutes of June 26, 2013.
I'll second that motion.
It's been motioned and properly second that we approve the License and Variance Board meeting minutes for June 26, 2013. All in favor, please vote.
Aye.
We're waiting for it to come on the screen. Okay.
Probably over the time limit.
Okay. All right. Well, we'll vote by hands, please. All in favor, please. All right. Motion passes unanimously. With that said, I'd like to declare this meeting adjourned at 11:59 a.m. Thank you.
Thanks. Here, I'll go on and give this to you. Certified by the city clerk for that meeting. Have that for later use. So on the next step, if you'll just talk to Scott. Scott will be back on Friday.
Friday, okay.
Yeah, and we've already discussed, we'll tee this up to have it heard by the mayor and council as soon as possible. Awesome. And it's a de novo hearing, so you can present everything you want.
We will not.
All again, that's fine. Okay.
We will not stop. We will not.
Just doing my job.
I don't think you've done your job, but thank you.
All right. Thank you.
Thank you, sir.
Run out of time, did it? Because that happened once before. It timed out. All right.
It's a function of when they.
But we went through the process with him, so. I mean, we had already told them that we Go through the appeal process to have it heard by mayor and council, and we try and get it on as quickly as possible.
After that Superior Court?
Yeah. Anyway, I'm sure Scott and I will continue to be involved in this matter. All you've ever used it for is a go-by for what's the meaning of a buffer, right? Yes. Oh, I know. Well, that's fine. I don't think I've said anything to you. See you later, Kim.
All right, bye-bye, Jeffrey.
Bye, Tim.
Bye-bye.
That's what I was going to say.
You know what's funny is about 15 years from now, some guy.
Probably Anthony's too.